So again, to go back now, Gabriel joined the Intellectual Property Office of Singapore in 2016. He serves as senior legal counsel and hears cases as hearing officer for disputes under IPOS's jurisdiction. Prior to public service, Gabriel practiced law in Drew and Napier after being called to the bar in 2011. And next, we have Margarita Cato joining us online. So Rita is an English solicitor and holds an LLB from the London School of Economics. Prior to joining the WIPO Center in 2020, Rita practiced at an international law firm in London and also worked at the firm's offices in Singapore and Geneva. Rita is currently the representative of the WIPO Arbitration and Mediation Center in the Singapore office. And finally, my co-moderator, I would like to introduce Mary Ann McGrail, who is the recipient of the 2020 G. Hamilton Law Award in the sole practitioner category. Mary Ann is a Harvard University alumna, earning her BA, MA, and PhD in English and American Literature, and is a past board member of the DC Harvard Club. So with that, again, everyone, a good afternoon, a good morning, good evening, and especially those in the United States, a very early morning to you. We will now start with the panel. Mary Ann, Rita, can you confirm if you can hear us online?
Thanks, Daniel. I can hear you.
Okay, perfect.
Daniel, we can hear you. Thank you.
Thank you so much. So to start this panel on understanding the fundamentals of intellectual property and arbitrability, I would like to first call on Nikhil to do a brief discussion on the concept of arbitration and the concept of arbitrability, as we are joined by a diverse set of practitioners online and on-site. Nikhil?
Sure. So I don't know what I did to get the easiest question, but there we go. So look, particularly for the law students who are joining us online, arbitration can be thought of as a consensual agreement to resolve a dispute outside of court through a structured process and a process that is generally adversarial. Because of the requirement of consent, and this sort of frames a lot of what we're going to be talking about, because of the requirement of consent, arbitration has effect generally only between the parties who have consented to the arbitration and who participate in the arbitration. This historically had led to limitations on the arbitration of public rights and interests, and registered IP was one of those areas which was thought to be a sort of a public right or a public interest not subject to arbitration. It's one of many in terms of the history of arbitration of public rights that previously could not be arbitrated, now often, or in fact generally can. Another one, for example, is competition law. Certain types of statutory claims in the United States used to be thought of as a sort of appropriate subject matter for arbitration. Those sorts of obstacles in common law countries, as we'll come to, are mostly historical in nature now and have been passed by and overcome. But that's something the rest of the panel will get into in more detail. Back to you.
Thank you. So any of the panel members would like to add on that?
Well, perhaps maybe I can just add a little bit on the IP side of things, building on what Nikhil just mentioned. So indeed, when we start thinking about IP rights, starting point, I'm sure many of you would expect, you would be thinking about things like a trademark registration or a patent registration. So those would typically have been issued by an IP agency of some sort. In Singapore, for example, IPOS would be the one that would be examining your application and then in due course issuing the certificate of registration. So, that would typically be what we would call an in-rem right, because it binds the world, or at least Singapore, activities that happen in Singapore, such that if you were to do certain acts which fall within the definition of an infringement of that IP right, then action can be taken against the infringer, per se. So the challenge or the tension that we would see when we deal with arbitration, starting from the position that, well, the reason why parties are in an arbitration is because they agreed to that arbitration, then you will quite naturally see that how then you deal with this perceived or potential tension, right, between a public right or the public monopoly that has been granted through the recognition of a particular IP right by the state as against parties who have submitted a dispute to arbitration, the parties who have a dispute between themselves. So I guess at the core of it, this is the issue that has arisen, and in I think in the US there were some questions as to whether or not IP disputes then are arbitrable. But as we will share in the course of the panel discussion today, you know, there has generally been not too much of an issue, essentially because notwithstanding that the arbitration process is what it is, the outcome of that arbitration is seen as binding on the parties who submitted to that arbitration agreement. So notwithstanding that we're dealing with a public right, there is an in personam effect almost that binds two parties to that arbitration outcome.
Yeah, Gabriel?
Sorry, you have to share the mic here. So I think one of the interesting things when we talk about IP arbitration is really what exactly is an IP dispute. Now, the starting point in Singapore, where Singapore has legislation which expressly clarifies that IP disputes are arbitrable. What's really interesting, so this is something that we tell people all the time, you know, in Singapore, IP disputes are arbitrable, but what does that actually mean? And what exactly is an IP dispute? Now, for this, we have to do the lawyerly thing and go back to the words of the statute. But I think that's really important because if you look at the provision, it says an IPR dispute, IP rights dispute, covers things relating to enforceability of the IP, infringement, subsistence, validity, and this is interesting because not every jurisdiction agrees about this. Validity, ownership, the scope of the IP rights, the duration, or any other aspect of an IP right. And the provision continues to talk about disputes over transactions and compensation. And in the definition of what is an IP dispute, I have it somewhere here. Let me scroll to it. So we have the traditional ones: patents, trademarks, geographical indications, registered designs, copyright, and so on and so forth. And it goes on down the list, and it ends off with any other intellectual property right of whatever nature. So this is really the position that we take in Singapore, that all these things are arbitrable. And when we think about arbitrability, what is really important is how it connects with public policy. Because you can't go there and say, oh, you know, the place where you did this arbitration, the seat, you know, it doesn't recognize that. No, that argument would not apply if you have an arbitration that is seated in Singapore that has the law of arbitration as Singapore law. Now, whether that is the case elsewhere, that I think is something that for certain jurisdictions, as Chung Yan has pointed out, is a little bit unclear. And I was just doing some research this morning because I recall reading some people saying that, oh, you know, in places like India, South Africa, those are places where IP rights can clearly are not arbitrable. But just today, and I don't know to what extent that this information is correct. I saw some 2024 developments. There's now an intellectual property arbitration center in South Africa, and apparently it's set up by some silks who decided that, hey, you know, this is something that having it not arbitrable is. And I don't know, you know, does this have force of law? How does it really work? But those are issues that different jurisdictions have to grapple with for themselves. But at least insofar as Singapore is concerned, we're very clear. These are all things, and we look at IP rights very broadly, things which are arbitrable in Singapore, I think.
Maybe just actually one thought on Gabriel's good point. You know, the if you look at the statute, there's a statute that dates back to 1983 is when it became effective in the United States, which states that patent validity, and having just pulled it up, any dispute relating to patent validity or infringement may be arbitrated. And it only talks about validity and infringement. Doesn't talk about ownership, inventorship, any of the other issues that Gabriel just listed, which is kind of an interesting point because at least, even as far back as I suppose now 5 decades ago, almost 4.5 decades ago in the US, there was not a question about whether IP disputes could be arbitrated. They could be. There was a question about whether the sort of global rights or the state-sanctioned monopoly effectively could be challenged in a private dispute resolution setting. And that it's that core question. I think even in other jurisdictions, you get on dangerous ground when you talk about a whole bunch of jurisdictions at once. But even in countries where there are challenges to certain types of IP claims being arbitrated, that doesn't mean you can't have IP arbitration. It's a question of sort of segregating and identifying issues. So.
Maybe I should also add to some of the perspectives around how it was that we ended up in Singapore having that legislative intervention in declaring that IP disputes are arbitrable. So also the starting point, a lot of this controversy was in a way, it has always been the case, or at least perhaps there are camps, but there was a significant camp which felt that there is actually no need to specify what's arbitrable as such. And, therefore you have instruments such as the New York Convention, which in fact, provide only very narrow grounds for challenge. And the only instance where you could have issues or difficulties over the enforcement of an arbitral award, Article 5(2) talks about where the subject matter is incapable of arbitration, settlement by way of an arbitration. And that was always very narrowly construed. There was also a model, the Unstral model law, which also stayed silent on the question of what is arbitrable. Rather, they stated a slightly different proposition, which is also reflected in the International Arbitration Act in Singapore, which is just a statement that when you have an attempt to get an arbitration proceeding stayed, the basis of that would be where it would be contrary to public policy. So very narrow starting points. And therefore, you had a bunch of people saying, look, why do we even need to put in place this legislation to declare, in essence, that IP disputes are arbitrable? And my sense was that there were certain jurisdictions such as Hong Kong, which actually decided that, look, we're just going to make this very clear. And we're going to implement legislation which says that IP disputes are arbitrable. And then, of course, Singapore also followed suit just to declare, in essence, right, make clear that we're not going to be in this space where there's going to be a question mark even as to whether the dispute's arbitrable, IP disputes are arbitrable.
Apologies for that. So, Rita, what's your experience in terms of arbitrability, particularly when it comes to various jurisdictions as in WIPO?
Thank you. So obviously the WIPO Center deals with arbitrations from around the world where the place of arbitration, the parties are free to choose what the place of arbitration is. And I'll just give my comments from a very just practical point of view, which is that in our experience, we haven't seen challenges to arbitration. So whilst it's theoretically possible for obvious reasons, in reality, when we've been around for about 30 years now, we don't know of any arbitrations really that have been challenged on the point of arbitrability. I know that in the past 10 years, I believe there was one case where a party challenged an arbitration, but it was on the basis of the jurisdiction of the tribunal, and ultimately that challenge was unsuccessful. So I would just say that in terms of our practical experience from around the world, when parties choose to arbitrate and they decide to submit their dispute, they intend for that arbitration to be the final resolution of that dispute in practice, and therefore they go through the process where they are able to obviously participate in selecting who is on the tribunal. They are able to express their arguments and have a fair trial, so to speak. And as a result, they respect the final decision of the tribunal. So at least, we have a positive experience in that in practice we haven't really seen this come up as an issue. Thank you.
Thank you. So earlier we've been talking so much about public policy and public interest. So from this perspective now, how does the concept of arbitrability really differ across various jurisdictions? And what's the role of public policy when it comes to determining arbitrability of IP disputes? So with this, Gabriel, maybe you'd like to start off.
So I think, okay, before I start off, let me just, earlier in the earlier part of this discussion, we've been talking about things in the very general sense. And we just need to come back down to the point that is that at the end of the day, when you have this arbitration, it's between the two parties or the parties that are parties subject to the arbitration agreement. And so that is both good and bad, because I think that may often give rise to issues where you have related parties that are not in the arbitration agreement. And that's something I guess we could talk about a bit later, subsidiaries, linked companies. And that's especially very, very common when it comes to IP, because that's how many companies structure, how many businesses structure their IP. Sometimes they park it or they manage it from one jurisdiction. Each jurisdiction has its own registrations, of course, but sometimes they are managed from different places. The licensor may be named in a different name from the party that is subject to the arbitration agreement. So these are all very, very interesting things that maybe we can talk about a bit later. But when we come back to the main question that Daniel has asked, how does the concept of arbitrability differ? I'm only going to speak from the Singapore perspective, and the short answer, I think, is that it really doesn't differ, right? Because everything we say is arbitrable, but it must be in between the parties. So even if it's validity, we can't oust the jurisdiction of the foreign tribunal, the court, to decide that as against the whole world, but in between the two parties themselves. That's something that is for the arbitration tribunal. So as how it affects trademarks, patents, copyrights, it applies equally. But I think the more interesting question is what happens when you have different types of rights that are not recognized by one jurisdiction, but not really by another. So, for example, just a very, very basic example, perhaps, is maybe in Singapore or some common law jurisdictions, you have the concept of passing off. But how does that relate, in jurisdictions which are civil law jurisdictions or jurisdictions which call it by a different name, trade dress protection or consumer protection, different things, right? So how does that work where things are on the periphery? So I'll pass the time on to somebody else.
Yeah, Chungyan is smiling, so I guess. So Chungyan, you have any comments?
Absolutely, I agree, with Gabriel, what you said. If we were to kind of step back and maybe think about what are really the public policy kinds of objections to the arbitration of IP disputes, I would have thought that the core issue would be what Gabriel identified, which is that goes back to the idea, right? The monopoly that is conferred by the creation or the recognition of IP right is a state-conferred monopoly. How is it then that we're having a dispute that is being settled by two parties through this alternative dispute resolution method going to impact the rest of the world? And of course, if it had that kind of a far-reaching impact, that an arbitral tribunal could declare a state-granted monopoly to be invalid, I think that, of course, would cause concern to many people. But that is in fact not the case insofar as what the outcome of the arbitration will be, because the outcome of the arbitration is confined to a ruling that binds those two parties. So as between the two parties, the patent is unenforceable for the reason that as between the two parties, it has been found to be invalid by the tribunal. And in that sense, you can see that I guess the public policy concerns are not as great, because the two parties basically said, and they agreed to this process of arbitration to resolve that dispute. They agreed for a tribunal to settle this or to determine the outcome of this dispute as between them. And indeed, then the tribunal has proceeded to say, well, I think there are issues with your patent or the issues with your IP right. And therefore, I'm going to hold that as between the two of you, the owner is not going to be able to enforce it. Nico?
It's interesting because the public policy objection that I am somewhat concerned about is kind of the opposite of Chunyan's public policy objection. So, one way of thinking about it is there's no obligation on the holder of the monopoly confirmed by the IP right to exercise that monopoly. It's a right. And so it's not that the government is saying, we expect you to be the, exclusive manufacturer of this patent item. So you can be. If you want to just grant a general license to the world, you can do that as well. And similarly, if you want to compromise or qualify your IP right through an arbitration agreement, you can do that as well. So that's all consistent with the idea that it is in a sense, an optional monopoly rather than a mandate to go do something with the technology on an exclusive basis. The public benefit that a court proceeding brings, though, is that it is a further test and challenge to the grant of right to the patent holder or the trademark holder or the copyright holder. And you are, to an extent, losing that in arbitration because the effect is only between the parties to the arbitration. So you are losing that additional check and challenge, and potentially you don't even, or the public doesn't even know it's being lost because the arbitration could take place in a non-public forum and could remain confidential. Which to me kind of, raises a question about, is there a policy direction to go here where the inter partes nature of arbitration in the patent and trademark and copyright space can be made optional rather than obligatory. So you can basically opt in as an IP rights holder that, I will have my rights challenged through arbitration. There's some real problems with that, including that you can then just pick the most favorable fora. So if it's used in a manner that excludes non-arbitral forums or the ability to go to court, then there's some real challenges with that. But it's kind of an interesting thought. Is it really the second guessing of the state monopoly that's the challenge, or is it the fact that that second guessing, that sort of check and challenge that the courts would provide, is no longer public, is no longer being provided as a benefit for the rest of the world? And that's hard to think about what to do about that. So.
Rita?
I think those are all very good points. I mean, yeah, that's what we always say is the main point being that the parties have decided amongst themselves that this is what they want to do. So that's the reason we don't really see a challenge. I mean, that's exactly what all the panelists have said. So I don't have anything to add. I thought those were very thorough answers. Thank you.
I think our co-moderator, Mary Ann, has a question for the panelists, a follow-up question in our discussion so far. Mary Ann?
Thank you all for your very helpful remarks. Given the significant differences between IP regimes in different countries, is IP arbitration essential now to the viability of cross-border IP transactions?
Maybe I can share some perspectives of that, because it's actually a corollary of what we were just talking about, because the state is not involved. And, typically in IP disputes, a defense to an IP infringement claim is invariably centered around issues as to whether or not the IP right has been infringed, and there might be different tests as to that. Whether or not the IP right is valid, and again, there might be different tests to that, bearing in mind that, of course, the wrapper of all of this is that IP rights are territorial, right? So each state will recognize your IP right, apply slightly different tests. The fact even that, the IP right even exists in the state may be different as a result of choices made by the owner of the IP, whether or not to even file IP protection. But the fact that parties may have agreed nonetheless to submit this dispute that they have to arbitration, and the process being what it is, that it is an inter partes arrangement between the two of them, it in fact allows for the resolution of multi-theater disputes. So the traditional way in which a owner of an IP right would have had to enforce that right would have been to go to each jurisdiction in which the IP right is infringed. And as you know, today, many corporations are multinational, they have operations all around the world. And the proposition is, in fact, quite challenging, because you would then have to initiate proceedings in country A, country B, country C, jurisdictions in which, the alleged infringing activities are taking place, or the breach of some license arrangement is taking place. The fact that parties may have agreed to arbitrate the dispute, on the other hand, allows for this tribunal that is constituted to then decide and resolve this dispute as between the parties on a global basis, not necessarily have regard to, the position or the nuances that might arise in each jurisdiction. So it's definitely got its benefits. And I would say, in fact, I've been involved in multi-theater disputes through the traditional court system. You will see, a whole multitude of different outcomes because because different legal systems take different positions in relation to substantive points, or you could get some of the courts saying that, oh, okay, because you've litigated this in some other jurisdiction, there is an estoppel that arises. So all sorts of complexities, right? And you're going to have to repeat this litigation, suing in each jurisdiction, not the most efficient of things. And that's where, if the parties say, let's just agree to arbitrate and resolve this as between us once and for all, globally, that's one of the key benefits I'd have thought in an arbitration process.
Okay, so thank you, Chung Lien, for that. Now, we do have a couple of questions also from the audience, but I think another relevant question here is that since we're talking about public policy and arbitrability, I think some members of the audience would like to know, does the concept of public policy change across various jurisdictions? Or is it, something that's just constant with one definition?
It's an almost it's a legal theory question almost. I mean, I think there's the question. There's maybe two ways to think about that. There's the question which Chung Lien alluded to, of public policy under the New York Convention and the scope of what that means, and that ideally would not have a different meaning jurisdiction to jurisdiction. It might. There are differences in the case law, but there's a single treaty and a single instrument that's being interpreted, and there's attempts to bring that together. Which I say with a little bit of hesitation, because I suppose the United States, where I am barred, is maybe a little bit of a laggard in terms of broad use of public policy. But the broader question, it's almost it's almost hard to answer without knowing the country you're thinking of, because we don't know sitting here, sort of what public policy, say, the Philippines, let alone South Africa, thinks is being vindicated by having patent disputes go through the court. And it's just kind of hard to venture a guess, I think.
Yeah, I mean, maybe I'm not the right person to say this, but at the end of the day, every country has its own interests to look out for, and what these interests are. It's not that one is any more valid than the other, but they all have different interests, and so that's why it flows that the public policy may be different. Yeah, so it's just a very simple.
Thank you, Gabriel. So in relation to public policy, we do have some questions from the audience, which I think we could tackle now. Considering that, we have a question from Ricardo Onquico. Wouldn't disputes involving the exercise of the IP office's administrative functions, such as registrability, are not arbitrable, since it's not strictly speaking only between two disputing parties, but also involving the state?
But I guess, that's exactly it. The outcome of the arbitration will not go to that issue specifically. The outcome of the arbitration is just to resolve as between two parties, whether, for example, hypothetically, a misrepresentation was made to the registration office in the process of prosecution, right? And that issue is ventilated in the course of the arbitration proceedings. The outcome of that binds the two parties to that arbitration, but it doesn't, in fact, affect the continued registration of the IP right, because it does not go then to open up, as it were, the decision to recognize the IP right. Now, it will be then for that party to go and challenge it through the normal the normal national processes available, if it was intended that would be the outcome.
And the result of the challenge might be totally different from what the arbitrator,
yes,
the tribunal thinks.
But you agreed that was how you would resolve your dispute, has its good side and its bad side.
Yeah. So, and as some commentators have observed, it could then lead into quite an interesting situation where between the two parties, and even more weird when it's a licensor relationship, the patents or whatever, the pharmaceutical things, the patent is invalid, right? And yet the licensor is still running all around the world saying, hey, do you want to pay me license fees to use my technology, to use my 3G, 4G, 5G, so on and so forth. So that's a very interesting question, but I think it's really more theoretical than real. I don't know, maybe some of you have seen or handled such cases, but I would imagine that those are quite few and far between. Most times it's really the commercial terms and issues that are being put to arbitration rather than very theoretical things like this.
Could I just add something there as well?
Rita. Yeah.
So on this point, we do occasionally get queries from parties where they essentially say that they've filed they're trying to enforce their IP right, and there's something going wrong with the national IP office, and can we help? And they'll provide us with lots of information about that issue. But our answer is that this isn't the right forum for this. Ultimately, we don't get involved in challenging national IP registries or any offices. I mean, sometimes there's a bit of a confusion because we're part of WIPO, that there's a belief or a misunderstanding that we have some sort of ability to negotiate something with an IP office, and that's not the case. But in any event, even just in terms of resolving a dispute, we always have to explain, both parties have to agree to submit this dispute. An IP office would obviously not participate in an arbitration, because they would just use obviously their own internal processes or administrative processes to deal with that challenge. So just wanted to add that. Thanks.
Thank you, Rita. So far we've discussed about intellectual property arbitrability, the concept of public policy, and we know it kind of gets difficult when you have to enforce it across various jurisdictions. So to help us with that, we also have invited our panel to give us some practical guidance for IP arbitration. So maybe Nikhil, you could start off with what do you think are the strategies that parties should consider when drafting arbitration agreements to ensure enforceability of awards and that IP disputes are arbitrable?
So I suppose one of the things we've been hearing is that particularly in common law jurisdictions and also in significant civil law jurisdictions, there isn't really an arbitrability issue. So you're thinking about it's almost, I think the way I'd frame the question is, how do you not get too focused on issues of arbitrability in a way that could sidetrack the dispute? So what do I mean by that? I think, for those of us who handle arbitrations for technology companies, life sciences companies, you'll often see these incredibly complex dispute resolution clauses, which is, we're going to go to arbitration, but if it's an infringement or a validity issue, then we're going to go to court. And if we need interim injunctive relief, then we're going to go to court. But if it's this other type of interim injunctive relief or the tribunal's been constituted, then you're going to go to the tribunal and, some other reservations after that. And that's the sort of stuff where what will end up happening is you will be in arbitration and in court simultaneously. You will get an award, and then the award will be challenged for having exceeded, some narrow exception that was baked into the arbitration clause. And one of the helpful things about the 2019, I think, statute in Singapore, about the Hong Kong statute, is that while actually, I think Chunyan is absolutely right. You shouldn't, as a legal theory matter. Why do you need it? Because you don't need to state what is arbitrable. You need to state what is not arbitrable. As a sort of, providing some confidence to practitioners, it's quite helpful to have that as a way of really simplifying arbitration clauses. And then what you're down to once you take this sort of issue of arbitrability off the table for drafting the arbitration clause is the normal set of decisions you have to make. What rules, what governing law, do you want a registry or for the arbitration, institutional arbitration or not? And that becomes much easier to deal with. And then to the extent you are operating in jurisdictions where there are arbitrability concerns, your carve-outs can be jurisdiction specific rather than issue-based, which in a way makes them kind of more discrete and easier to argue about.
Yeah, I think Rita has an additional points, and then we'll entertain the questions from the audience. Rita?
Thank you. So I agree very much on the point on clauses. So we run various workshops and training sessions on drafting of clauses, and we publish model clauses for arbitration, including tiered clauses where, for instance, you might have mediation followed by arbitration. And one of the points we make is that arbitration clauses should be straightforward, and the sort of chopping and changing and sort of saying that one part of the dispute will go to court and another to an arbitral institution, or even we've seen clauses where parties have decided that the commercial aspects of the dispute will go to an arbitration center, whilst the IP aspects of the dispute will come to the WIPO center, which is extremely confusing. And I think sometimes there's a belief that it's quite clear what is an IP issue and what is a commercial issue, but the reality is that it isn't. And you can always make a challenge. Well, for instance, if you're disputing the royalty rates, is that an issue to do with the patent, or is that an issue to do with just how much what value you place on the patent, which is kind of a commercial issue, because obviously you can debate how much you should license your patent for. So one of the points we always make is to avoid doing things like that. We do publish model clauses, and we answer questions frequently from law firms or from companies regarding the clauses, just to understand what they mean. And we even publish a clause generator where you can go through and you'll be prompted to answer questions about your dispute and what are you trying to achieve, which you can then check with us. But we do obviously one of the things we point out is all the different points that should be addressed, such as which rules will apply, what is the place, for instance, the language and the choice of law. All these types of things are addressed. But for us, we always emphasize that simplicity is very important in practice. Thanks.
Thank you, Rita. The questions from the audience.
I'm I am head of the impact of telecom company in Singapore. I find it very interesting that you mentioned the fact that the arbitration clauses are actually sometimes not drafted the other way around. And in fact, the one who might be pushed to arbitration for everything under the sun except for IP. So, specifically out recently. Yeah, and there are several reasons for that. I mean, you're aware of the fact that issue. So, apart from the argument of the jurisprudence behind the arbitration deal, you would note that I know that this new act is done under the auspices of the AA, the Arbitration Act. So, technically, every other reason or justification or argument for the benefit of arbitration or any other commercial matter would apply, in terms of resolution. The IP, but it's still the IP in a sense not much different for but from our perspective, in the telecom company especially, the majority of it actually is not related or infringement, aka patent use, or whether it's possible regularity or even licensing fee. And most of the time, these disputes arise actually the issue behind this going on inter-parties private basis actually is the impossibility of this type of award. As I said, it doesn't come with the usual teeth or bite that you would have if you had an order of to kind of enforce it. If it again, we have the regular arbitration clause kind of deal with commercial aspects where we find that parties will tentatively come to the table via private arbitration and get something sensible for an award. But if it's regarding infringement, I'm not sure if the current regime is all that usable, very practical practice, especially for companies like us. As an active example, we have one current IP litigation that was around both royalty fees as well as patent scope in the US. They have been running for 6 years for damages of $5 million. I can't remember but there, even with the court system, it's gone through every single level of appeal possible, and we're still fighting the appeal on appeal. So in such a case, I don't really see how that would have any benefit had the parties at the hindsight of benefit of arbitration, for example, and adding on arbitration because this with the court process, it's taken us 6 years to still fighting on it. So I'm just wondering whether there's inside the framework or practical experience when infringement makes the majority of the concern, whether then private arbitration will be.
Chung Lian, maybe before we give you answer, just to clarify and for the benefit of the audience online, Eugene, your question is if the problem concerns infringement, whether arbitration is still proper? Yeah.
So, my perspectives on the issue are these. When we talk about arbitration in the context of an IP dispute, we've got to also remember that a very important threshold issue is that the parties have even agreed to submit the dispute to arbitration. So in practice, invariably where the parties would have agreed to such a to the arbitration would typically have been in cases where the parties have had some kind of a commercial agreement that was entered into between them, a license agreement of some sort, maybe it's an R&D, research collaboration, whatever it is. There was a pre-existing relationship, and as part and parcel of the contractual documentation or the agreements establishing that relationship, they decided, okay, let's put in an arbitration clause, an agreement to arbitrate, so that if disputes were to arise, we would refer it to arbitration. And of course, yes, there are all those attendant benefits that perhaps, yes, civil law versus common law jurisdiction, it may be easier to enforce an arbitral award. There are definitely some benefits to that. In the case of where you're dealing with a specific issue of infringement, typically a third party who has had no prior relationship with you as the IP owner, then actually arbitration is not the default option unless there has been an opportunity for both plaintiff and potential defendant to first agree to arbitrate that dispute. And so in that context, I guess I can mention, and Rita can discuss, can share her perspectives, but this is where if the parties don't have that prior relationship, WIPO and other agencies can potentially help by saying, okay, are you guys prepared to agree to submit this to arbitration? And that process then kicks off. So is it very often that you will see a pure IP infringement case go to arbitration because of that threshold issue? I guess certainly perhaps not as common relative to where the dispute arises as in the context of a pre-existing arrangement. Why? In the throes of war, where parties basically cannot see eye to eye, invariably they don't want to make life easy for the other party. And so, they will invariably not be very cooperative. But of course, if the practical common sense of things prevails and they do in turn then agree to submit the dispute to arbitration, then yes, it can trigger this. Now, more generally, very, very interesting question. Are contractual disputes and infringement of IP rights necessarily distinct issues? I think in practice, very difficult sometimes to differentiate. Why? If parties enter into a license agreement, basically you have the owner of the IP, right, consenting to or giving a license to permit the licensee to practice the IP within the scope of the terms of that license agreement. What is the definition of infringement of an IP right? Where a person or a party has done something within the scope of the IP monopoly without the consent of the IP owner. So there you have this overlap, right? When exactly can we say that this is clearly only a contractual dispute because perhaps the party has not paid money, the royalties that were due under the contract? And does that fact then mean that this continued use of that IP, as will often happen, right, then translates into an IP infringement claim? Can you not then sue for IP infringement as a result of this person breaching the terms of the license agreement? So there are some of these, questions which do complicate things, and the distinction between the two, to me, are not always that clear. Don't know whether.
Yeah, I mean, I think there's two other interesting issues raised by the question. I mean, one is, are there sometimes benefits in speed and predictability to just not using arbitration at all? One that this is outside the scope of IP, but one area where that comes up is a lot of banks just won't put arbitration clauses in kind of large scale loan documentation. And they'll say, we're going to go to court in London or we're going to go to court in New York. And they do that because first they think it's faster. They think that judges know what they're doing. They know who the judges are. They kind of know who they're going to get. And they have the benefit of public precedent. So if they think that the forum is reliable and will apply its own precedents in a reliable way, They want to benefit from that, and they want to continue building the precedents because they're repeat players. That's there could be for companies in the technology space as well who are used to using particular courts. There could be reasons that you just don't want to use arbitration as sort of a policy, or policy is the wrong word, but as just a business matter. It's not meeting your requirements. The other interesting question, and I don't know if this is the situation you're referring to, but you can think of contractual relationships that really aren't about IP, but something could go wrong that has to do with IP. And so, if you think about this, you could have just a distribution agreement. If you're manufacturing TVs and you have an agreement with, Target as a distributor, there could be all sorts of just routine issues that come up that you want to be handled in arbitration. Sorry, Target is a US retailer. I'll have to use a different example, but Amazon, whoever it is, but you're the department store, like you may want to have all of the delay in delivery of the television set is going to be handled by an arbitrator, or they're not marketing it in the right way is going to be an arbitrator. But if they then turn around and start manufacturing a generic television that looks exactly like yours, that's a very different type of dispute from what you're contemplating when you're drafting the contract. It's bad faith by one of your business parties. You may not want that to be handled in arbitration. And maybe there is some call for complexity. I think the instinct that a lot of us arbitration lawyers have is it's really that complexity is something you have to use cautiously because it can be used to slow you down. So what you can have happen is in that unexpected dispute, maybe you do want to carve it out, maybe you don't want to be in arbitration, but you can also find yourself fighting about the right forum for years, literally, if you do carve it out. So it's just sort of a trade-off.
Rita?
Yeah, I would add on the point of kind of courts and whether parties prefer to go to use court litigation or arbitration. At least in the context of IP disputes, one of the interesting points is that IP is obviously highly specialized, and depending on the jurisdictions, of course, there are specialized courts with judges who are very experienced in dealing with certain matters. But globally, that's not the case. So there are jurisdictions where, we obviously have a close relationship with many judiciaries around the world, and they seek out training in relation to IP because they don't actually have that experience because perhaps their jurisdiction IP is not yet a large part of their sector, so they just don't see those types of disputes very often. So one of the reasons we always give for choosing arbitration, at least in relation to IP disputes, is that you are able to choose your arbitrators. So you have confidence that they have a knowledge and understanding, or even if you have no issue with explaining or doubting a judge's ability to understand new concepts, the point is still that you would still need to spend time explaining those concepts, perhaps appointing experts, etc., which can delay matters. So one of the reasons, at least for IP specifically arbitration, is that you're able to select arbitrators that have the necessary niche background and knowledge of your industry area. And as we all know, IP can become very, very niche. So this is a really important point. Thank you.
Are there a lot of questions that are coming up? If not, there's some. So Eugene, I'm not sure if the questions your concerns have already been addressed by the rest of the panel, but I just wanted to add that I think in whether speaking from a Singapore point of view or a commercial point of view, at the end of the day, and this is something that we will be talking about soon, everybody appreciates that there are reasons why you should arbitrate in certain circumstances and why you should not. So I'm not sure in your specific case whether you're chasing somebody down, asking them whether they want to come to the table and submit the dispute to arbitration, or whether you're thinking about infringers which would never agree, as Chung-Lin has said, or whether you are thinking about end consumers, which give rise to a whole different issue, right? So and that is a whole different ballgame altogether when you're talking about click-through contracts and I agreed to arbitration. So those are all different things. But I think there's of course an appreciation in this space that it really depends on your commercial objectives. And especially if you want to get the court order and wave it around at the rest of the industry and say, hey, this is, don't mess with me, right? So it really depends, I guess.
Okay, in relation to what you just said, Gabriel, I'd like to move on to the next question, which is what are the potential advantages and pitfalls of choosing arbitration over litigation for resolving intellectual property disputes?
Starting first?
Yeah.
Well, so um, um, the team at IPOS, we actually teach a course at NUS Law, and this is like the first question that what are the pros and the cons of arbitration versus litigation, and like I say, it really we've been talking about. It really depends on the commercial objectives, but I guess just coming back to the point that we have not yet talked so much about, which is confidentiality. I think this is an area which has been of great interest to parties who willingly want to seek out arbitration as the forum, the place to resolve their disputes, because they don't want their trade secrets to go beyond a certain point. They want the documents that are supposed to be disclosed to be controlled by certain rules of procedure, which they hopefully can agree on. They want things not to be in the public eye, so to speak. And so this is something that perhaps we can talk about a bit more. But I think this is an area which really brings it's always touted as one of the interesting things about interesting features of arbitration versus court hearings, which are increasingly public. And I understand that in certain courts in the US, they have live stream proceedings. In the UK, I think also, and everybody can hear what it is about. Of course, you can go to court and then say that, can I have this part sealed? Can I have and then when you read the dispute, and then you don't, especially for patent disputes, I don't understand half the judgment because I have no access to the technology, to the evidence that was before. And then, I can vaguely appreciate what the court is saying, but I don't have a full understanding. And that is the point which the parties wanted. Now, of course, in court, that's one thing, but in arbitration, that's another. And perhaps we could use this as a launch point for talking about other things as well.
Nikhil, would you like to add?
Sure. I mean, I think one important advantage is one that Chunyan mentioned earlier, which is if you have a multi-jurisdictional IP right portfolio, you can resolve the dispute more quickly, potentially in arbitration, or you can get a single independent adjudication that at least has the potential to have the force of law in a bunch of different jurisdictions if you go get it, recognized and enforced in a bunch of different jurisdictions. So that is a primary advantage. And another one is trust. You don't need to trust the courts of your adversary's home country. But I think those are maybe the two most frequent that I hear, but Junior, I don't know about you.
Yeah, I would agree, with what Gabriel and Nicola have shared. I think the most important concept is in an arbitration, party autonomy as a concept is, one of the core underlying foundational ideas. By that, it means that just as the parties have chosen by this arbitration agreement to arbitrate, to use that process to settle the dispute between them, they equally also have the flexibility to determine how that is going to be done. And that means, in turn, choice of the tribunal, right? Basically, who's going to be hearing the dispute, choice of the rules. So I'm sure Rita, she can share more about how, for example, WIPO, in having developed the arbitration rules, we've got specific mechanisms for addressing things that might arise in the context, more frequently in the context of an IP dispute, for example, experiments and stuff like that. So there, equally to your point, you know, if you survey litigants across the world, everybody has differing views about discovery, right? And the extent to which you're supposed to engage in it. And again, the resort to an arbitration kind of a way of resolving the dispute gives you the flexibility then of deciding the extent to which you're going to engage in that. Rita?
Thanks. I actually just wanted to add a point on the confidentiality, which is very important, obviously, and the WIPO rules do have very strong provisions in relation to confidentiality, because that's a major point. And what I would like to add here is that often that we have queries, particularly from like academic institutions, as to, you know, publication of arbitration awards. You know, would we want to, could we have access? And of course, that's not possible. But in any event, just queries as to why parties want to keep things so confidential. And I think the answer here is very practical, is that unless there's a specific reason to make something public, why would you risk making it public? So I have had conversations with parties who are pursuing litigation and in multinationals, for instance, and I've queried just, you know, generally, you know, what were your reasons? And they say, well, in our case, we actually want to go to court litigation because we want everything to be made public. We want to demonstrate that our IP rights are entirely valid, that these are the rights attached to them, et cetera, et cetera. But in other cases, we also, of course, have WIPO mediation. So I know this is a little bit off topic, but equally, we will have mediations where the parties are actually already in court. So this is already public knowledge that they're disputing, but they still don't want anyone to know that they are mediating. And you might say, well, why not? Everyone knows you're in a dispute because they're really an issue. But from their perspective, it's kind of a business strategic point. Like, why disclose what our strategy is? Why disclose that we will mediate? What is the benefit to us because they don't know what could be the potential disadvantage of disclosing that. And I think obviously with arbitrations, that's a huge reason, is that you can just keep everything confidential and you are confident that nothing will come out that you didn't expect to come out from the very beginning, because it's obviously not clear what can come out of a court procedure, what kind of disclosures need to be made, and so that's a huge reason why parties will choose arbitration. And of course, on top of that, it's the trade secrets aspect. It's just releasing any kind of information. Even if you seal things, it's still a concern. There's always still a risk that something might be disclosed. You just don't know. So where you have an IP dispute where the information is the most valuable asset, it's just a matter of you just kind of risk profile and saying, well, why are we risking any of this? Like, let's just keep it confidential and that be the end of it. Thank you.
I'm just going to add something about cost, because everybody loves talking about cost. There for a longest time used to be this conversation about how arbitration is getting more and more expensive. But thinking about it also in the time is money perspective, I think Chung Yen alluded to this, earlier in talking about how centrally everything could be, controlled and disposed of. And Eugene earlier mentioned about the disputes going through 6 levels. And can you imagine, as we have alluded to, this happening in so many different jurisdictions? In arbitration, of course, there is much more finality. Of course, you can set aside the award in circumstances, but those are pretty limited, public policy. But then that's just a different story, right? But we go back to the main point. It's usually quite difficult to set aside the arbitral award, and whereas you have so many levels of appeal in the domestic court system, and each one could disagree with each other. And more interestingly, of course, and I guess perhaps this is more of a feature of the common law system, you have courts looking at what each other are doing, and perhaps a dispute in Singapore, they'll say, hey, there are parallel disputes in the UK. It's same patent family or same, substantially the same, but maybe with some minor variations, and then the lawyers will fight over the extent to which those are material. And let's wait for the court has already heard this. Let's wait for 2 more weeks, and then we see what happens. And then you have further submissions in the courts here. So all these things add up to the cost, and even if not, I mean, at least in the way that it drags out. So I think this is also a huge issue. Yeah.
So now we're, talking about court litigation and arbitration in general. So in choosing between litigation and arbitration, what do you think are the concerns of parties when it comes to the availability of interim measures of protection and other similar remedies?
So, that is one area where going to a court may have benefits. So in, taking the US as an example, generally interim measures of protection and other interim orders are enforceable. There's no statute that says so expressly, but courts have interpreted the Federal Arbitration Act to do so. Oh,
Yeah, thank you.
But the problem is you can go through a full set-aside challenge in US courts on the interim measure, which makes the interim measure a little bit beside the point, depending on the nature of it. There's a whole lot of different kind of questions that come up in terms of, the nature of the dispute and the type of urgent situation that you're contemplating might occur when you're drafting the contract, because even as you're litigating the validity of the interim measure, if you're in violation of it, you might be held liable and have to pay damages for violating it if you're not respecting it. But that is one area where going to court, you immediately get something enforceable. The flip side, though, is again coming back to the point of you only get something enforceable in one place, not across the board. And so that is, often kind of a very commercial set of considerations to take into account when drafting the contract.
Chung Lian?
Well, I guess the only thing I'd add to that is also to bear in mind what the rules that the parties may have agreed to apply say about the availability of recourse to the courts for interim relief. And of course, different jurisdictions have different degree of tolerance as well, in terms of the statutory provisions that they may take as to availability or otherwise of these kinds of relief. But by and large, I think, most of the more commonly applied sets of rules these days, they do still allow for emergency relief applications to court. But, like I said, party autonomy, you can choose your rules, so please choose wisely. If this is an issue, and of course, particularly in the context of IP, it always invariably is an issue, right? We should injunct these guys, make them suffer, even as we sort this out, the dispute out. Please do pay some attention to the rules that you're applying and making sure that the relief is available.
Rita?
Yep. So we do get questions as well about the availability of interim measures. And I mean, under the WIPO arbitration rules, the tribunal does have an explicit power to order interim measures, which includes injunctions. And actually our tribunals see those kinds of requests with some regularity. So the WIPO rules, explicitly mention, injunctions and measures of conservation for the conservation of goods. And the tribunal can order that the requesting party who's requesting the interim measure also provide some sort of security for that request. Of course, there are situations where the interim relief that the party is requesting may not be within the tribunal's power. So, for instance, where a third party is involved. In those sorts of cases, the WIPO rules do make clear that you can go to a national court to request at least such interim measures, and that would not be at odds with the arbitration rules. So at least from our perspective, we don't really see this as an issue. Again, same point. The parties have chosen to submit their dispute to arbitration. They have they've agreed to that. Therefore, if the tribunal orders some sort of interim relief, they would need to comply with that because that's what they've agreed to do in the first place. So yeah, thank you.
Okay, thank you, Rita. So I think we're a bit pressed for time. So with that, before we move on to the questions from the audience, and we do have a lot of questions from the audience, maybe we could just ask you one last question. What is the impact of the rules agreed upon by the parties in bringing intellectual property disputes to arbitration? And maybe Rita, you could start off with the WIPO rules as well.
Well, I think parties need to consider the rules to see I think sometimes it's a lot, we see sometimes the parties will just say, well, we've always just used these rules, so we'll just go ahead and continue using them. But I think it is important for parties to kind of consider the timelines and what are the actual what will be the procedural steps? Does it fit their schedule? To what extent can they amend those? For instance, if interim measures are a concern, how is that addressed in those rules? At least for the WIPO arbitration rules, there is flexibility. So we do provide for, if the parties want to change some deadlines, if they want to do something else, if provided they all agree and the tribunal's in agreement, they are free to do so. But I think it's important for parties to, consider the rules before they just elect them in their clauses. Thank you.
Julian or?
We probably don't have time.
Yeah.
So.
Yeah. So, Mary Ann, there are questions from the audience online. So maybe could help us.
Sure. First, what is the best way to integrate a mediation arbitration referral system in IP disputes?
I'm happy to take that question since we have quite a clear way to do that. So as I mentioned earlier, we do publish model clauses, including tiered clauses, where you can say that you will attempt mediation within a certain period of time, and if it's unsuccessful, you can then proceed to arbitrate. And there's various ways for doing this. So, for instance, you can say that we'll try to mediate for 30 to 60 days, and proceed. Following that, we will arbitrate. And we've also included optional language where you can say that if you, for instance, set aside 3 months to mediate, and then after that you can proceed with arbitration. If one party doesn't even engage in the mediation process, so let's say just don't reply to anything, you don't have to wait the entire 3 months, because obviously that's just a delaying strategy. So you can say, okay, if the party doesn't reply or actually engage meaningfully, you can proceed to arbitration earlier than that. So those are the ways for doing that. Equally, of course, you can attempt arbitration and then use mediation during the arbitration. So perhaps 6 months down the line, you can request that there is a pause in the proceedings, and the parties may set aside a month, let's say, to mediate. So there's lots of different ways for doing that, provided, of course, the parties agree. But in practice, of course, it's useful that if you would like to mediate, you would just want to try 1 month to sort things out amongst yourselves before kind of pulling the trigger on an arbitration. It's obviously useful just to have that in your clause already, rather than wait until the point where you're actually at the point of arbitration, and perhaps you haven't thought about mediation, and then you need to try and persuade the other party to mediate. Of course, they may agree, and we deal with a lot of requests for mediation where one party wants to mediate and the other hasn't agreed yet, and we will approach the other party and try and help them understand what is mediation, what does it involve, because sometimes the other party is just not familiar with mediation. Depending on the jurisdiction, it's just not something that's done, so that can be useful. But obviously, again, in practice, it's useful just to have it in your clause when everyone is in a good mood and they're about to sign their agreement, to say, okay, if something happens, let's try mediate. We're hopeful that we can sort things out, and if not, we will go to arbitration.
I'm just going to add something from the Singapore perspective. So the SIAC and SIMC, Singapore International SMC also, SIMC, right? So we have the ARP protocol, and that the essential aspect of that really is to have the parties start with arbitration and then go to mediation. If they are successful, they can get that consented, got it with a consent arbitral award, and then that allows the parties to then have that mediation enforced in any one of the New York Convention states. So I think that's pretty useful. If it suits the purposes of the parties.
I think we also have another question, Mary Ann, from Ricardo Onquico.
Yes, we have two new questions. Let me go first to Mr. Ankiko's question. Sorry. In the Philippines, I understand there are very few arbitrations involving IP rights because the IPO processes for such disputes are very efficient, both in time and cost. If in other jurisdictions, do they have the same experience? If not, what kind of IP disputes are commonly arbitrated in other jurisdictions?
Okay, like I mentioned, what we would see quite often would be the disputes that come up, say, in the context of some relationship, commercial relationship involving the use of the IP in some way, whether it's a license agreement or to create some research collaboration type of an agreement. Invariably, I think that's where a lot of the time these sorts of disputes do come up, and because of that agreement to arbitrate, the matter ends up being referred to arbitration as such. Nico?
No, I mean, it's very often collaboration, joint venture, asset acquisitions. I think, sort of M&A type asset acquisitions will result in disputes. So where there's something broader between the parties.
I think just to add, the question probably is thinking about it from the domestic perspective. And I think in Singapore also, the domestic arbitrations for IP probably are going to be few and far between. What we usually hear of are the international ones. So that's really where our focus is, and that's where the cases are.
Okay, do we have any questions from the audience on site? Okay, if none, Mary Ann, I think we have one last question online.
Yes, we do. This is a question, I believe, for Rita. For WIPO, how do your costs compare to other institutions? What other factors could we mention to a client in recommending you or your rules over others?
So all of our costs are published online. So this is all available, so you can compare and contrast between the various institutions in that regard. One of the main points that we raise as to why parties come to us is, one aspect is our costs are fairly low. We're not here to try and make the biggest profit in the world, because obviously our mandate as being a part of WIPO is we're trying to assist parties with resolution of IP disputes in order to promote a global IP system. That's kind of our, reason for being, as opposed to simply trying to charge the highest fees that we possibly can. In terms of other reasons, one is that the point I mentioned earlier, which is the ability to appoint arbitrators and mediators who have specific knowledge of certain IP rights or industries. So where parties don't know who to appoint, perhaps particularly with cross-border disputes, in terms of our cases, both mediations and arbitrations, I believe over 70% of our cases are international in nature. So where you have that situation, parties aren't familiar with the jurisdiction, they don't know who exactly to appoint, etc. They can approach us and ask, because we have lists of neutrals for almost every country, for every area, so we can help them. And that's kind of the major reason for why you would use WIPO Center as opposed to perhaps other institutions that are not as specialized with IP disputes. And yeah, I think that's kind of the main points I would want to raise. Thanks.
Any other comments from the panel? If none, I think it's time for us to close. We're a bit over time. So with that, thank you everyone, the esteemed members of the panel, for this very enlightening discussion. And so to close our ceremonies here, I would like to call on my co-chair for the Intellectual Property Interest Group of ASIL, Mary Ann, to do the closing.
Daniel, thank you very much. We'd like to thank the attendees in person and the over 90 people who attended online. The Intellectual Property Law Interest Group of the American Society of International Law, along with the Intellectual Property Office of Singapore and the Dispute Resolution Interest Group of the American Society of International Law, are the co-organizers. We'd like to thank our co-organizers. Also our sponsors, Covington and Burling, and Wong partnership, and 3 supporting organizations, the DC Bar International Law Community, the Singapore International Arbitration Center, and the Philippine Institute of Arbitrators. Thank you all for attending this webinar. We'd also like to apprise you of the fact that the Intellectual Property Law Interest Group has 2 upcoming webinars, one on intellectual property tech transfer and green technologies on September 27th, and another on current topics on artificial intelligence and intellectual property on October 29th. You can sign up for these virtual programs on the ASIL website, www.asil.org. I put that in the chat. Thank you all for coming. And we'd especially like to thank our excellent panelists for a great discussion. Thanks.